Welcome back to SCOTUS Oral Arguments and Opinions. We've got some catching up to do after a couple weeks away, including a recap of a heated emergency docket battle that had Justice Kagan firing on all cylinders. Then, we'll examine Maryland versus Shatzer, a 2010 case that tackles a deceptively complex question. When must a suspect re-invoke their right to counsel during police interrogation? For those just joining us, welcome! And don't forget to follow along for more Supreme Court deep dives. Now you may be asking yourself, why Shatzer? Two compelling reasons. First, Shatzer demonstrates how precedent can live a double life. When the decision came down, everyone focused on its headline holding, that suspects must re-invoke their right to counsel after time passes and custody ends, essentially limiting certain Miranda protections with a bright-line 14-day rule. But here's the twist. Over a decade later, in Vega versus Teco, the court cited Shatzer for entirely different language buried in the opinion, Justice Scalia's reasoning about how judge-made constitutional rules must be narrowly construed. What seemed like a case about interrogation timing suddenly became ammunition for questioning the enforceability of Miranda rights entirely. And second, here's where it gets really interesting. Shatzer showcases Justice Thomas at his most consistent. Regular listeners know Thomas takes every occasion to skewer judge-made constitutional rules. In Shatzer, you'll see that philosophy in action, as Thomas questions not just the majority's reasoning, but the entire enterprise of judicial rulemaking itself. Credit for Shatzer case analysis goes to our undergraduate intern. She's been invaluable this summer. Her work on constitutional criminal procedure has been particularly sharp. We'll continue to feature her work as the summer reaches the homestretch. Let's start with the regular docket, where we have one significant development. Remember Louisiana versus Callais, the voting rights case that had oral arguments last year, but got mysteriously relisted to this term? Well, the mystery deepened on August 1st when the Supreme Court ordered the parties to file supplemental briefs addressing a pointed question: whether Louisiana's intentional creation of a second majority-minority congressional district violates the 14th or 15th Amendments. That supplemental briefing order signals something big may be brewing. For decades, the Supreme Court has interpreted the Voting Rights Act to require states to intentionally create districts for racial minority groups. But this new question suggests the justices are reconsidering that foundational interpretation. Given the court's recent skepticism toward race-conscious government action, we may be witnessing the setup for a major shift in voting rights law. That's the only action on the regular docket this week. No order lists are on the horizon, which means the justices are likely taking their August recess seriously, at least when it comes to new case decisions. But as we'll see, the emergency docket never sleeps. The emergency docket told a very different story. While the regular docket sat quiet, the emergency side delivered exactly the kind of high-stakes, precedent-shaking decision that's made this procedural pathway so contentious. This case, Trump versus Boyle, where presidential firing power collided with congressional design for independent agencies. On July 23rd, the Supreme Court issued a stay, which allowed the Trump administration to proceed with firing members of the Consumer Product Safety Commission, CPSC. Picture this. 3 CPSC members show up to work one morning only to discover they no longer have jobs. President Trump fired them, not for misconduct, not for neglect of duty, but simply because he wanted them gone. There's just one problem. The statute creating the CPSC explicitly states that members may be removed by the president for neglect of duty or malfeasance in office, but for no other cause. The fired commissioners weren't going down without a fight. They sued, and the district court agreed. These firings violated federal law. The court ordered their immediate reinstatement, but the government had other plans. Enter the emergency docket, where the Supreme Court's most contentious battles now play out at lightning speed. The government raced to the Fourth Circuit seeking a stay, arguing they'd suffer irreparable harm if these commissioners returned to their posts. The Fourth Circuit said no, so the government did what any litigant does when lower courts won't cooperate. They appealed to the highest court in the land. Here's where it gets interesting. The government's argument basically hinged on Trump versus Wilcox, an earlier emergency docket case that let President Trump fire NLRB members. Same authority, same result. The government essentially argued the CPSC commissioners wield executive power just like NLRB members, so Wilcox should control. Check the show notes for a link to our episode on Wilcox. On July 23rd, the Supreme Court agreed. In a brief order, the court issued the stay, declaring that Wilcox squarely controlled the issues. The fired commissioners would remain fired, at least while the litigation continued. But that's where the real fireworks began. Justice Kavanaugh penned a concurrence that essentially said, "Why are we dragging this out? When the court's going to narrow or overturn a precedent anyway," he argued, "why not just grant certiorari immediately and settle the question once and for all? Lower courts can't overrule Supreme Court precedents, so further percolation serves little purpose." Then came Justice Kagan's pointed dissent, joined by Justices Sotomayor and Jackson. She opened with guns blazing. Once again, this court uses its emergency docket to destroy the independence of an independent agency as established by Congress. Kagan painted a picture of congressional intent under siege. Congress deliberately structured the CPSC as an independent bipartisan commission to ensure consumer safety decisions wouldn't be subject to political whims. For decades, this structure worked exactly as Congress intended. But now, Kagan argued, the court was dismantling congressional design through the emergency docket's back door. Her most damning accusation, the court effectively overturned Humphrey's executor versus United States, a nearly century-old precedent protecting independent agencies, without the usual rigorous analysis such a momentous decision demands. Instead, they did it with the scantiest of explanations, relying on the poorly reasoned Wilcox decision as their sole justification. This emergency docket battle exemplifies a broader tension that's reshaping American law. How much precedent should bind the court? And what's the proper forum for overturning established doctrine? These questions aren't just academic. They're fundamentally about how our constitutional system adapts and evolves. Speaking of precedent and evolution, today's deep dive takes us to a case that perfectly illustrates how Supreme Court doctrines expand and contract over time, and how a single decision can stand for radically different propositions as legal landscapes shift. In Maryland versus Shatzer, we'll see how the court grappled with the enduring power of a suspect's request for counsel, ultimately crafting a rule that would later become a foundation for scaling back Miranda protections entirely. The case focused on what happens when a suspect tells the police, "I want a lawyer." How long does that protection last? A few hours? A few days? Indefinitely? While all 9 justices agreed on the outcome, the judges fractured in their reasoning, particularly Justices Antonin Scalia and John Paul Stevens, who had very different views on how the Constitution should work in this context. Let's begin with the facts. In 2003, Michael Shatzer became imprisoned after prosecutors convicted him of child abuse in an unrelated case. That year, a detective visited Shatzer in prison to ask about a new allegation involving Shatzer's own son. Shatzer invoked his right to counsel under Miranda, and as required, the police immediately stopped the questioning. 2.5 years later, in 2006, a different detective reopened the case. The detective read Shatzer his rights again, and this time, Shatzer waived them and agreed to speak. Shatzer did not re-invoke his right to counsel. Shatzer made statements that incriminated himself. Shatzer's incriminating statements included a confession to committing child abuse. Prosecutors charged Shatzer with second-degree sexual offense, sexual child abuse, second-degree assault, and contributing to conditions rendering a child in need of assistance. Shatzer waived his right to a jury trial. In a bench trial, the judge found him guilty of sexually abusing his son. The evidence largely consisted of Shatzer's incriminating statements. Shatzer appealed. His attorneys argued that his 2006 statement should have been excluded because he invoked his right to counsel years earlier. Under a 1981 case, Edwards versus Arizona, if a suspect asks for a lawyer, police cannot reinitiate questioning unless the suspect does so voluntarily, or unless the suspect is no longer in custody. The trial court found that Edwards didn't apply because Shatzer returned to the general prison population, which it considered a break in Miranda custody. But the Maryland Court of Appeals disagreed. It reversed the conviction and ruled that prison still qualifies as custody. The case then moved to the U.S. Supreme Court. So here's what the Supreme Court was wrestling with. Can police come back and reinterrogate someone who previously said, "I want a lawyer"? To solve this puzzle, the court had to dig into a fundamental question. What exactly constitutes a break in Miranda custody? Now, the court wasn't starting from scratch here. The justices looked to Edwards versus Arizona, the landmark case that deals with coerced confessions after someone invokes their right to counsel. Edwards established a clear rule. When a person asks for a lawyer, police cannot obtain a valid waiver of that right if police try to interrogate that person again while still in custody. But here's where things get really interesting. Edwards involved just a one-day gap between interrogations, while Shatzer's case had a massive 2-year gap. This timing difference presented the court with a brand new question. Should Edwards still apply when so much more time passes? The court's answer was a resounding no. What's fascinating here is how Justice Scalia approached this problem. Writing for the majority, Scalia first made a crucial distinction. Edwards amounts to a judicially crafted rule, not a constitutional requirement written in stone. This matters because judge-made rules aren't permanent fixtures. Instead, these rules only make sense when their benefits outweigh the costs. The court explained that Edwards' logic works well when someone remains in continuous police custody or gets reinterrogated immediately after invoking their right to counsel. In those situations, the person stays isolated in a police-controlled environment where officers could easily pressure them into changing their mind. Think about it this way. Edwards works perfectly when someone remains locked up in continuous police custody or gets reinterrogated immediately after asking for a lawyer. In those situations, the person stays trapped in an isolated, police-controlled environment where officers can easily wear down the suspect's resistance and pressure them into changing their mind. But Shatzer's situation was completely different. After police removed Shatzer from that police-controlled environment for 2 full years, the risk of police coercion essentially evaporated. The court realized that extending Edwards to cover this situation wouldn't serve Edwards' original purposes. Instead, application here would block voluntary confessions without preventing any actual coercion, meaning the costs clearly outweighed the benefits. So the court declined to apply Edwards to Shatzer's case. But that decision created a new problem. If Edwards didn't apply, how should the court decide the case? Enter the court's solution, the break in Miranda custody test. This new test examines 2 key factors: the duration between questioning sessions and the suspect's environment during the period between interrogations. If an extended period passes between questions, or if the suspect lives in a non-coercive environment between questioning sessions, then a break in Miranda custody may occur. And here's the kicker. If there's a break in custody, then a person must reassert their right to counsel when police approach them again. Applying this new test to Shatzer's case, the court found that police reinterrogated Shatzer after a massive 2-year break. Now, here's what might surprise listeners. During this entire time, Shatzer remained locked up in prison, but according to Justice Scalia, lawful imprisonment imposed upon conviction of a crime does not create the coercive pressures identified in Miranda. Wait, how can prison not be coercive? Scalia's reasoning gets to the heart of what Miranda was really trying to prevent. In Scalia's view, life in the general prison population lacks those isolating and coercive elements that Miranda was designed to stop. Scalia explained his logic this way. When a suspect has been released from his pretrial custody and has returned to his normal life for some time before the later attempted interrogation, there is little reason to think that his change of heart regarding interrogation without counsel has been coerced. He has no longer been isolated. He has likely been able to seek advice from an attorney, family members, and friends. But what does normal life mean for someone behind bars? Here's where Scalia's analysis becomes really intriguing. Specifically addressing prisons, Scalia painted this picture. interrogated suspects who have previously been convicted of crime live in prison. When they are released back into the general prison population, they return to their accustomed surroundings and daily routine. They regain the degree of control they had over their lives prior to the interrogation. Sentenced prisoners, in contrast to the Miranda paradigm, are not isolated with their accusers. They live among other inmates, guards, and workers, and often can receive visitors and communicate with people on the outside by mail or telephone. Their detention, moreover, is relatively disconnected from their prior unwillingness to cooperate in an investigation. Because Shatzer returned to his usual prison routine without solitary confinement, increased security, or any pressure tied to the original questioning, Scalia concluded that the coercive environment ended. For these reasons, the court found the situation amounted to a break in Miranda custody. But the court's analysis didn't end here. The justices realized that law enforcement officers needed clear guidance, not some vague standard that would require case-by-case determinations. So the court adopted a bright-line rule that police can reinterrogate a person 14 days after invoking their right to counsel, given that the person does not re-invoke their right to counsel during that second encounter. Now, this raises an obvious question. Why exactly 14 days? What's fascinating is Scalia's candid admission. The number was not based on scientific data or empirical studies. No researchers conducted experiments proving that 2 weeks satisfied a magic threshold. Instead, Scalia argued from a practical standpoint that 2 weeks provides enough time for a suspect to return to normalcy, reflect on their situation, consult counsel if desired, and decide independently whether to speak with police. Scalia aimed to strike a balance, too short a time period, and suspects might still feel the lingering pressure from their initial interrogation. Too long, and law enforcement investigations could stall indefinitely. The court settled on 14 days as that sweet spot, long enough to dissipate coercive effects, but short enough to allow meaningful law enforcement work to continue. With this framework in place, the outcome became clear. The court reversed the judgment of the Maryland Court of Appeals and upheld Shatzer's conviction. In essence, the justices ruled that Shatzer's 2006 statements were perfectly admissible because the 2-year gap in general prison population constituted a valid break in Miranda custody, far exceeding the court's new 14-day threshold. Shatzer's confession would stand, and his conviction would remain intact. Justice John Paul Stevens concurred in the judgment, but strongly disagreed with the 14-day rule. Justice Stevens maintained that prison remains a custodial environment. Prisoners cannot leave, and the state controls their daily lives. Stevens warned that assuming a suspect could access legal advice, family, or friends within a 14-day window was unrealistic. He also questioned the fairness of allowing interrogation to resume without ever providing the suspect with the counsel they previously requested. He wrote, "Unless police warn suspects that the interrogation will resume in 14 days, why contact a lawyer?" Stevens stressed that the pressures of interrogation do not disappear simply because time has passed. He noted that until law enforcement grants a suspect's request for counsel, inherently compelling pressures remain, pressures which are stronger for a detainee who has requested a lawyer, an act that may signal their inability to cope. Justice Clarence Thomas wrote an opinion that concurred in part and concurred in the judgment. Justice Thomas agreed that returning to the general prison population breaks Miranda custody. However, he rejected the 14-day requirement altogether. He saw it as arbitrary and lacking legal foundation. Justice Thomas recognized that under prior precedents, judge-made safeguards against compelled confessions must maintain the closest possible fit between the rule and the Fifth Amendment interests they seek to protect. Justice Thomas stated that the 14-day rule, as opposed to 0, 10, or 100 days, fails to provide the closest possible fit with the self-incrimination clause. Since the majority already concluded that a break in custody occurred, Justice Thomas believed that was all that was necessary to decide the case. Over a decade after Maryland v. Shatzer, the Supreme Court returned to Miranda in a case called Vega v. Teco. In that case, A police officer questioned Terrence Taco without first giving Miranda warnings. Prosecutors used Taco's unwarned statement at trial, but a jury acquitted him. Afterward, Taco filed a lawsuit against the officer under Section 1983, arguing that using the unwarned confession violated his Fifth Amendment rights. The Supreme Court said that people cannot sue under Section 1983 if police coerce a custodial confession without reading the person their Miranda rights. Writing for the majority, Justice Alito explained that Miranda rules are designed to protect constitutional rights. But they aren't constitutional rights themselves, and that matters because Section 1983 only covers actual constitutional violations. A Miranda violation, standing alone, doesn't qualify. To support that reasoning, the court looked back at Shatzer. In that case, the court had already said the Edwards rule was a judicially crafted safeguard, not a constitutional command. Vega used that same idea to go a step further. The majority emphasized that courts can shape, limit, or even eliminate these safeguards when the costs outweigh the benefits. In Shatzer, that thinking led to a bright-line rule. Police could reinterrogate after 14 days. In Vega, it led to a much bigger shift. The idea that a Miranda violation no longer opens the door to a civil rights lawsuit. So over time, Shatzer evolved. What started as a rule about breaks in custody became a foundation for scaling back Miranda itself, turning a once robust protection into something more flexible and, in some situations, unenforceable. Thank you for listening to SCOTUS Oral Arguments and Opinions. If you enjoyed this episode, follow, rate, and share it. Stay tuned for more breakdowns of Supreme Court decisions.